Yes.
My Lord, we just had a look at the fact that Ukraine had paid the interest.
Yes.
In our submission, performance of the contract is an absolutely classic method of ratification. And Ukraine's only answer to this is to say that the interest payments were made, what it says is mechanistically by mistake. By mistake, I think what they mean is that they didn't know that the Minister of Finance had exceeded his authority. But it's worth at this point just looking at Brown and Inovaratone, a decision of Mr. Justice Hamblin, as he then was, which is in volume 6 of the authorities at tab 50. Page 2476. Also, the report, it's a very long case which starts at 2335, but the relevant part is at 2476, and I'm just rely on it for the statements of the law. And you can see it on page 2476 at paragraphs 856 and 857, he quotes from the then edition of Balstead, and at 858, he explains that knowledge, you have to have knowledge of material acts that is important. As knowledge of the legal effect of the act may be imputed to the principal, he does not need to have actual knowledge of the legal effect. In this case, therefore, the claimants would need to know that the exercise of the DA was in excess of would not need to know that the exercise of the DA was in excess of the authority. As stated in Balstead, where the principal is aware of the agent's acts, the terms of the purported contract, it appears not to be necessary that the principal had realised that the agent had exceeded his authority. Assent may be manifested by the principal's commencing to perform the contract, and where, to the principal's knowledge, the third party commences to act on it, the principal may become stopped from disowning it. Ratification can occur without, that's a slightly different point, but the simple point is, ratification, you have to show that there is an act which objectively constitutes ratification, and all that you have to show is knowledge of the transaction, but not that the transaction is in excess of authority. And the same point, we can put that away if we could go to the third bundle of authorities at tab 22 to Balstead again at page 1338. See the nature of the test at 2-78. That's dealing with no necessity for communication. And then over the page, what one's looking at in the second sentence is where the manifestation to the third party, it's the next part. In accordance with the general principles, it's objective appearances that matter, not the internal intentions of the principal. And they quote from the Suncorp case, which was a decision of Mr. Justice Waller. It seems to me it shouldn't be open to a principal who, to the outside world, by his conduct or that of his duly authorised agents, appears to have adopted a transaction to be able to prove subjectively that he in fact had not. So it is just an objective test, looking at it, whether you are adopting the transaction and whether an objective view would be that. So that's the payment of interest. It wasn't only payment of interest that occurred, as I made clear. Ukraine included the notes in its exchange offer in 2015. That's referred to in the defence at paragraph 88, and in Mr. Mason Jebb at paragraphs 84 to 92, which is in Appendix Part 2, Volume 1, MS 8983 to 5. And as part of the exchange offer, the Parliament actually passed a law authorising the Cabinet to impose a moratorium on external debts. And that law in May 2015, in its appendix, actually identifies the notes as ones to be included. And that's in Appendix Part 2, Volume 5, MS, pages 10419 and 10421. Oddly, in their written document, you need to treat that with caution, Ukraine refers to alleged notes or alleged debts when referring to what happened at this time, but there was no reservation or anything of that sort prior to December 2015. And in the same vein, they invited the Russian Federation as note holder to exchange the notes, and that was in September 2015, and in October they issued the exchange offer memorandum, which is in Appendix Part 2, Volume 5 at 10459. So there's no dispute about any of these acts. They're all acts which classically constitute ratification. As I think I explained earlier, the issue really is about knowledge, but as Mr. Justice Hamblin's case shows, that you don't have to have knowledge that the agent had exceeded his authority. And that position that Mr. Justice Hamblin made is also made in Balstead at 2-71 in tab 23 of volume 3, MS 1363. So in our submission, Ukraine tries to deny ratification on the basis that it says it didn't know that the Minister of Finance had acted in excess of authority. And we say that's just even if it were true, it would be legally irrelevant. But in any event, they would be stuck with constructive knowledge. And particularly, we only get to this point because Ukraine has succeeded in saying that the trustee is treated as having knowledge of all these things. Well, if the trustee is treated as having knowledge, what's sauce for the goose is sauce for the gander, then Ukraine must also be treated as having knowledge. So the logic of their case on authority applies equally to them. The final point that arises before we consider the duress point is the argument that the person whose act amounts to ratification has to have authority, they say, to approve an unauthorized transaction. That is entirely contrary to English law. What English law provides is that the agent, if it's an agent who's doing the act of ratification, he has to have authority to do the act which constitutes the ratification. So, for instance, the Treasury had to have authority to receive the money. Whoever paid the interest had to have authority to pay the interest. And that's Balstead 262, which is in the Authorities Volume 3. There is an update to it, where the language has changed slightly. It's in tab 23 of that volume at 1362. But in our submission, Balstead hasn't there's been no change in the law, and there's no suggestion in Balstead that there's some authority that would change the position. So, and I think the other relevant authorities we've referred to in writing. So that, we say, leaving aside the arguments on duress, there's an overwhelming case of ratification. So all that leaves is, does the duress argument defeat ratification? Well, in our submission, the first point is, if we're right on what we've previously said about the duress defence, then then it's irrelevant as a matter of English law. But in any event, there are two flaws as to why, even accepting the premise of their duress case, why it doesn't work. The first is a very simple one. Ukraine's case is that it performed all of the ratifying acts because it did not know of the absence of actual authority. In other words, Ukraine's case is it was paying the interest because it believed it was obliged to pay the interest. So it's impossible, logically impossible, to say it was doing these acts because it was fearful of Russia's duress, when it was actually doing these acts because it understood it was under a legal obligation to do them.
Oh, I see. So the argument is that acts which might otherwise ratify a lack of authority don't count if they were acts undertaken under duress.
Yes, but in fact, on their own evidence, it wasn't duress that caused them to do this. Or their evidence is it was that we believed we were legally bound by the contract. The other point we make about the duress case and why it is factually untenable is that what the duress case has to say is that I was doing this because my will, as it were, my assent to these acts was deflected by the duress, but that sits uneasily with everything else that Ukraine was doing in making complaints to the Security Council, bringing proceedings against Russia in the European Court of Human Rights, campaigning in the UN General Assembly, and so on. We've set it all out in writing. And in our submission, it's difficult to see how Ukraine can have a sensible case that it only undertook the ratifying conduct because of fear of the Russian Federation. And indeed, of course, what it could have done is to disown the obligations and simply pay back the money. So, my Lord, we say this is an overwhelming case of ratification if one needed to get there, but we say you don't. So then I briefly, in the last 30 minutes, want to address the countermeasures points. And the argument, which you pointed out to you yesterday, was given pretty short shrift in the Court of Appeal, is that Ukraine is entitled to resist enforcement of the notes in reliance on the international law doctrine of countermeasures. Now, the first point I would make is that this argument and the way it was developed is very revealing in respect of the approach that one takes to these international law questions. What is going on here is Ukraine is saying, I don't want to pay these English law notes because Russia, they say, has wronged me on the interstate plane in international law. Now, just stopping there for a moment, that has nothing whatsoever to do with domestic law. So, in relation to countermeasures, Ukraine is upfront about the fact that what it's trying to do is to shoehorn international law issues into domestic law where they would otherwise normally be irrelevant. Now, they accept that in order to do that, they have to have a domestic foothold. So the domestic foothold that Mr. Jaffe seeks is to show that these international rules are incorporated into domestic law so that they become relevant. So, in other words, what is recognized is you can't simply say, well, the trustee is suing on an English law contract and I want to defend myself. Because my defense relies on an issue that arises in international law, that gives me a domestic foothold. In other words, it goes back to that point at paragraph 159 of the Court of Appeal's judgment and the difference between Mr. Thankey and myself as to what is the right approach to domestic foothold. And it's interesting to draw the contrast between the position that Ukraine takes in relation to the duress part of the case and the position that they take in relation to countermeasures. And we suggest that they've got the right position in countermeasures, which is you can only get there if you can show that this has been incorporated into English domestic law. Now, the difficulty with countermeasures is, the starting point is what the Court of Appeal said at paragraph 189, which is the doctrine of countermeasures only operates at the level of international law. And as they said, in the absence of a domestic foothold, the English court has no proper role in examining it or pronouncing upon the merits of the arguments put forward. And as my Lord Lloyd-Jones pointed out yesterday, even on its own terms, the international law doctrine of countermeasures applies only to a state's refusal to comply with an international obligation. It has no application to a state refusing to comply with domestic legal obligations, and certainly not to a standard debt obligation under tradable notes. There's not a single case anywhere in the world which we're aware of or which has been cited to you where the doctrine has been held to apply anywhere to a domestic law contract. And the simple point is it's got nothing to do with domestic law rights. Now, Mr. Jaffe accepts that the only way in which this international law doctrine could have any potential relevance if it has been incorporated into some way in accordance with the test of this court in the KU case. And there are three flaws with the argument. First, as my Lord Reid pointed out, the courts can't act as the legislature. The courts might in certain circumstances be able to amend and adapt common law rules by reference to international law, but it's not within the court's purview just to invent and incorporate and apply whole doctrines of international law hitherto unknown to the common law. Ukraine's position, when asked what domestic law rule was being adapted to accommodate this countermeasures doctrine, was that the court should simply adapt domestic rules on, and I quote, self-help and set-off, justification and frustration, and then that old unruly horse, public policy, also made an appearance. Now, this is totally incoherent. Firstly, as far as I am aware, there is no domestic defence to a contract claim of self-help or justification. Indeed, it would be a rather interesting extension to commercial lawyers of the law of contract. What's more, the international law doctrine has nothing to do with English law of set-off or frustration. The reliance on public policy also gives the game away, as it's relied on as a sort of get-out-of-jail-free card, trying to explain why irrelevant international law concepts are supposedly relevant to domestic law rights. It was suggested that the Court of Appeal had somehow endorsed this approach to contract, whereas all the Court of Appeal said was that countermeasures doctrines in international law related to ideas of self-help and self-defence, got nothing whatsoever to do with the English law of contract. And that's enough to dismiss all of this. Secondly, if one were to incorporate these international law rules into domestic law, you would be bringing into domestic law a whole range of problematic and contentious interstate issues, which these courts have said time and time again are not matters that fall within the constitutional responsibility or competence of the courts. And that takes you back to cases that are well known and which we've looked at, Gentle, Jones, Mohammed Sardar, and the principled approach that in determining the existence and scope of a domestic right, one has to consider where you're seeking to invoke an international law doctrine, you have to consider what the exercise of it would entail. And one only has to look at those cases to see that the idea that one would invoke an international doctrine which required the court to determine the appropriateness of interstate conduct and proportionality of responses and things like that, it's entirely contrary to the whole run of cases. So that if Ukraine was right, the court would be required to determine not only whether the Russian Federation had committed an internationally wrongful act in relation to Ukraine, but also whether Ukraine's response was an appropriate or proportionate one in international law. And as I say, Belhaj, Al-Haq, Jones, Gentle all show that these sort of issues are not ones for the English court. The third point is it's totally unclear how any of this would work where you have tradable notes under a corporate structure. The obligations in this case are not owed to the Russian Federation, they are owed to the trustee. So the doctrine is totally ill-adapted to be a rule of domestic law. And it certainly shouldn't operate to the prejudice of a party like the trustee or potentially other note holders. Furthermore, the doctrine of countermeasures only gives rise to a suspension of obligations while the internationally wrongful conduct of the other state is happening. So if one just thinks about that, how is this supposed to operate? Is the court supposed to say, well, I'll consider the conduct of the Russian Federation at this stage, and I'll say the obligations are suspended, and then the parties will all come back for the English court to decide at some stage whether or not the conduct has improved. It's just something that the courts would be totally ill-suited to do, to make ongoing, constant determinations as the conflict between parties on the interstate plane played out. And Lord Neuberger made it clear in KU that you don't incorporate international law if it could have potentially wide and uncertain ramifications. It's difficult to think of wider or more uncertain ramifications. Now, up to this point, one's been assuming that there is a sufficiently defined customary international law rule which could be identified and applied. Now, in our submission, Ukraine hasn't begun to establish what the parameters of the countermeasures rules are, even in international law. And as Lord Sumption explained in the Benkar-Bush case, to establish a rule of customary international law, you must show that there is a widespread, representative and consistent practice of states on the point in question, accepted by them on the footing it's a legal obligation. That's paragraph 31 in Supplemental Authorities, tab 3, page 233 at 263. So it's not enough just to assert, oh, everyone thinks there's a doctrine of countermeasures. You need to show that this is a widespread, representative and consistent practice of states. Ukraine points to one report by the International Law Commission, and in our submission this is manifestly inadequate and provides no sound basis for concluding what customary international law exists, let alone that it's something that can be incorporated. And so in our submission, this is all untenable. Now, the only authority in English law that's looked at this is the decision of Mr. Justice Coleman in the Westland Helicopters case, which is in Authorities, volume 18. tab 173, MS 7086. And the relevant part of Mr. Justice Coleman's judgment is at 7112, between letters E and F. The problem about issue 2 is that it involves considering whether the conduct of 3 Gulf states was such as to amount to a wrongful repudiation of the treaty, and whether insofar as Law 30 imposed a control regime for AOI which differed from that in the treaty, it represented a justifiable response in PIL. Because of the principles of non-justiciability, an English court can decide neither issue A or B. Such issues can be decided only by reference to public international law, by a public international law forum and not an English municipal court. For both issues necessarily involve the determination of whether foreign sovereign states are acting consistently or inconsistently with the rules of public international law. It's thus unnecessary to investigate what impact this part of the case has on these proceedings. Now, that is obviously entirely inconsistent with Ukraine's submissions. Now, as I understand Mr. Jeffy, he says, well, this case, Mr. Justice Coleman's, was before Kuwait, and it's to be reconsidered in the light of the Kuwait Airways decision. Now, in our submission, that actually throws a spotlight on how Ukraine misuses and misapplies Kuwait, both on the countermeasures issue and indeed on the duress issue. Kuwait Airways, as we've seen, was not a case where the court was being asked to say that rules of international law were relevant to a domestic law right. Ukraine seems to be approaching the case on the basis that it means that all international law rules are somehow incorporated into English law for determination, or that the court somehow has carte blanche to determine issues of international law wherever someone alleges they are breaches. But that's not what Kuwait was about at all, and as we pointed out, it's a rather narrow case about the court deciding not to apply a foreign law of a state confiscating property where the UN Security Council had determined and the state had acknowledged that the confiscation was indeed in violation of international law, and critically that the United Kingdom was itself under an international obligation not to recognise the foreign law. There is no such international obligation in relation to this case. It was also suggested that Belhage somehow affects the position. It does not. As I explained, and is very important to bear in mind, Belhage was not a case about a court being asked to determine that international law is relevant to a domestic law right, as Ukraine seeks to do in both the duress and the countermeasure issue. All that Belhage was about was a standard domestic tort claim, and it was saying that if the foreign act of state doctrine applied for any reason, that doctrine might be disapplied where there are allegations of breaches of some types of behaviour, like torture, which are prohibited in international law and which are already well known to English law. What it doesn't do is create domestic law rights, and it doesn't make international law somehow relevant to domestic law rights, which is what Ukraine needs to establish. The final string to the bow was reliance on the Freedom and Justice Party case again, which we've looked at in Volume 2, Tab 12, MS 915. I don't think we need to turn it up. You'll remember that concerned a narrow question concerning immunity of special missions. It's plainly not analogous to the sort of issues that Ukraine seeks to rely on in this case. And one should note that forms of immunity for states or diplomats are obviously well known to English law and were part of English common law before the State Immunity Act 1978 put them on a statutory footing. As Lloyd Jones pointed out, That case, the Freedom and Justice Party, like Kuwait, was about a situation in which the United Kingdom was obliged under an international law to recognise the immunity of the special mission. So that's, when you look at that case and Kuwait, it's one of the key features. Now, just before I conclude, Mr. Jaffe made some points by reference to the United Nations General Assembly resolution about Russia's conduct in Crimea and sought to suggest that was somehow relevant. It's not, for a number of reasons. First, as a matter of fact, the General Assembly resolution was 100 out of 169, so it's not exactly universal. Mr. Jaffe suggested that the only difference between a General Assembly resolution and a Security Council resolution was that the General Assembly couldn't authorise use of force. That is just manifestly wrong. Resolutions of the UN Security Council are binding on all member states, whatever their subject matter, and member states are obliged to carry them into effect pursuant to Article 25. There is no such obligation in relation to General Assembly resolutions. So, for instance, if you remember the Al-Haq case, the fact that the General Assembly may, as it has from time to time, criticise Israel, that is nothing to the point where there is no Security Council resolution. And the fact that there's no Security Council resolution is what means that, for these purposes, what the General Assembly may say is neither here nor there. So in our submission, this is not in any way analogous to Kuwait, for the reasons I've explained. Now, in conclusion, one thing I would like to do is to remind you of the Court of Appeal's judgment and reasoning when it dealt with implied terms, because much of what the Court of Appeal says there is relevant to the sort of arguments that are being made here and in relation to the duress case. So if you go to paragraph 209, the Court of Appeal, this part of the judgment was authored by Lady Justice Gloucester. Paragraph 209, she explains that the structure of the obligations was tradable bonds, and it was irrelevant that Russia remained the holder of the notes, or even that it was anticipated it was likely it would continue to do so. And she says the character of the notes gave rise to certain consequences which were strong counter-indicators against the implication of the suggested implied terms. And the first point she makes at subparagraph 1 that it's obvious that any implied terms have to be derived from the contractual documentation available to subsequent holders as well as to initial holders, and she refers to the BNY case. And then, having quoted from that, on the next page, that letter between letters D and E, she says, although these cases were dealing with the interpretation of the relevant contracts rather than implication, similar principles apply. The notion that terms could be implied into the general circumstances surrounding Russia-Ukraine state relations at the time of execution of the relevant agreements, relieving Ukraine from its payment obligations if the original note holder in the future conducted itself in a particular way in its international relationship with Ukraine, so as to be binding on subsequent note holders, would be wholly contrary to such principles. And then in the next paragraph, she makes it clear that it would be contrary to principle and common sense to imply into a Eurobond transaction between Ukraine as issuer and law debenture as trustees terms relating to the relationship between Ukraine and Russia. Now, of course, all of this is dealing with implied terms, but in our submission, Ukraine is trying to do exactly the same or something very similar in relation to the countermeasures issue and the duress issue, which is to bring irrelevant international law matters into the context of a contractual claim. In our submission, the reasoning in relation to implied terms applies with equal force in relation to these other areas. So, my Lord, those are my submissions on countermeasures. The other point that is raised in the written case is an argument for some other compelling reason for trial. That wasn't addressed orally by Mr. Thankey, so I don't propose to say anything more about it.
Can I just press you on that last point, Mr. Howard? The fact that Russia isn't a party to the trust deed wouldn't prevent Ukraine maintaining that it had entered into the trust deed as a result of coercion or duress, rather, by through pressure exerted by Russia. The person exerting the pressure doesn't have to be a party to the subsequent contract.
Your Lordship's entirely right. If one's asking, am I saying because it's only law debenture that Russia, that Ukraine can't run a duress defence by reference to the conduct of, could be Russia or anybody else? The answer is yes, they can. The more fundamental point that I'm seeking to allude to is whether matters on the international plane are matters which form part of English law and provide a basis for a defence to an English law contract.
You are saying in relation to countermeasures, it is relevant that the counterparty is law debenture rather than Russia.
Well,
you're saying a third party can exercise duress to make A contract with B, third party C can be the instrument of coercion, but I think you are saying, if I understand your submission correctly, that it is relevant that law debenture is the counterparty.
The established law of duress allows you to rely on duress by a third party, so I accept that. But what one's got to remember, what one's dealing with is countermeasures, is a countermeasure which is between two states, and you're using that countermeasure in relation to a contract which actually the other state isn't even a party to, and you don't necessarily know whether he will or won't be at the relevant time.
Yeah. So the fact that it is relevant, the law debenture status as counterparty is relevant, you say, to as a factor pointing against countermeasure.
Yeah, it's right at the bottom of the list, as you, I think, appreciate it. So you just don't get there for a whole host of other reasons.
Yes, thank you.
And clearly, the fact that the notes are tradable on an exchange might well have the consequence that that even assuming that duress was otherwise available as a plea to Ukraine, they wouldn't be entitled to avoid the notes if, for example, the current note holders were bona fide parties who had paid large.
I don't think that's right at all. I know your Lordship mentioned that. We're not dealing with a situation with equities darling or anything of that sort. So if the party entering into, short of an estoppel or something like that, but if it's simply you're saying, well, if I'm induced by duress to enter into a contract, the fact that the contract has been assigned to somebody else won't prevent me avoiding it because there's some new third party.
Well, you would expect. Well, I'm just wondering about that. If I mean, it's accepted that Russia would have a plea, would have a claim in restitution.
Well, of course.
But they may not be good for the money.
But the claim in restitution, remember, once you go into this sort of thing, if Russia has sold the notes to let's say, to hedge funds, or whatever, the hedge funds sue and it said, well, it was duress that caused us to do this,
Yeah.
and so we're not liable. The hedge funds won't have a claim in restitution because they didn't
Yeah.
pay Ukraine.
Yeah.
So they would have to have a claim against the person who sold the notes to them. That would depend upon the terms of sale and what risks they took, what warranties they had. Now, one can see that there could be complications as to whether, because the normal law is that you have to make restitution of the benefits you received.
Oh, quite.
But the restitution normally would be to the party from whom you've received the benefit. Now, but on this case, got to remember, if we get to restitution, what one apprehends is that Ukraine is going to say, well, I don't have to make restitution because I've suffered injury in some other way.
Yes.
And how all of that would play out if there were third-party note holders, one would have to wait and see if you had a case which concerned that.
Yes, thank you. Yes, Mr. Thank you.
My Lord, if I have quite a lot of material to cover because I've got to do ratification as well for the first time in our submission, so I'll try and rattle through this at some pace. But I'm going to start with capacity, if I may. One of the premises of the Court of Appeal's approach on capacity was that English law imposes no restrictions on the capacities of those who have legal personality as a matter of English law. In our submission, the vice of that approach is that assumes that all sovereign states are to be treated as English legal persons when litigating in England by dint of recognition, and we as the Court knows, dispute that premise. The Court of Appeal, as we discussed yesterday and Lord Carnworth mentioned in argument, the Court of Appeal expressly relies on English domestic law concepts of capacity at paragraph 65 and at paragraph 71. But that is applying the domestic concepts of capacity, which was rejected as the meaning of capacity for the purpose of the choice of law principles as expressed in the Haugesund case we looked at before, because for these purposes, conflict of laws, in order to minimize potential conflict between different legal systems, strives for comity and to avoid that type of narrow parochial view of concepts which apply across borders, as it were. And the Court of Appeal at paragraph 69 quoted from Buckley that the powers of bodies corporate incorporated by charter are the same as those of an individual and are not limited by any provision of the charter. But even charter corporations can be prevented from exercising their powers if they're purported to be exercised beyond the powers in the charter. And one sees that actually from the Court of Appeal decision itself, when they quote from the Sutton's Hospital case, paragraph 68. And this approach of the Court of Appeal of some sort of default rule of unlimited capacity obviously doesn't apply to individuals, including foreign individuals. One could take the example of a minor, where the age of majority may vary from one jurisdiction to another. And there can also be questions where a foreign individual is concerned. The better view is that the place of domicile will dictate their capacity. And we cited a case in our skeleton, the Nizam of Hyderabad case, where Mr. Justice Marcus Smith said that represents the better view, as adverted to in Dicey. So we have at least first instance authority that domicile is likely to dictate the capacity so far as individuals, foreign individuals, are concerned. And to be fair, and this is a point that my Lord Lord Carnworth mentioned in argument, that the reference to and the application of domestic law in this context to foreign sovereign states is ultimately an assertion and not based on any authority. And we accept that. But we would add to that point that that is ordinarily a classic reason for refusing to give summary judgment where there is no decisive English authority on the point. Better to be decided after full consideration of the facts at trial, including expert evidence and rival expert evidence, unless at trial the trustee completely accepted Professor Butler's evidence, and one listening to Mr. Howard rather doubts that would be the case if this case goes to trial. And I cited in opening the World Online and iWay case, where Lord Justice Sedley made this point, that the lack of decisive English authority is normally a good reason for refusing summary judgment. And as I also said in opening, the absence of authority certainly doesn't reflect, and this case demonstrates, any universal market understanding that capacity is governed by English law, where you have an English law governed contract. And the best evidence one has seen in this case, before this court, is the fact that opinions were sought and delivered in relation to the contractual capacity of Ukraine, notwithstanding the English choice of law in the contract. The next point on capacity is that recognition in our submission is not constitutive in any sense beyond conferring legal personality. The Court of Appeal itself, at paragraph 64, agreed that sovereign states were not an English legal person of any kind, just as the ITC was not an English corporation. The trustee comes close to saying that that is wrong, and the reference is day 3, page 132, line 25, where Mr. Howard said that recognition creates the person on the domestic, i.e. the sovereign state, on the domestic plane, and we say that's wrong. And references to clothing with legal personality, for example, at Court of Appeal, paragraph 63, are apt to mislead because they are ambiguous. For example, in dealing with foreign quasi-corporations or something unrecognizable to English domestic eyes, such as the temple in the bumper case that Mr. Howard mentioned, the temple, it was recognized as a person in Tamil Nadu, even though, as Lord Justice Purchase said in the bumper case, it was little more than a pile of stones. So it doesn't come within any English concept of a natural or non-natural person that would be recognized. English law doesn't normally recognize temples or piles of stones as able to sue, but it respected, as a result of comity, the law of Tamil Nadu. Because the temple, whether it was a pile of stones or more, because it had rights under Tamil Nadu, that would be frustrated if it could not sue in this jurisdiction. And it was afforded personality for those purposes, i.e. standing to sue. But one can't derive any more than that. The English decision in Bumper clothed it with legal personality, but it didn't make it an English legal person. And it didn't make its capacities governed by English law. The authorities relied on by the trustee need to be treated with a special care. There were 2 articles in particular that Mr. Howard referred to, and they use the concept of constituting in a way which is ultimately not consistent with the trustee's case. First, there was the Professor Mann article at Authorities Bundle 20, tab 200, MS 7720. That just says that an unrecognised state does not exist or is a nullity, but that's the same as a foreign unincorporated association, or if the court had refused to treat a foreign temple as a person. It says nothing about, it's just saying it has no personality. It doesn't go any further. The Marston article in the same bundle, Authorities Bundle 20, tab 202, MS 7730, that article is all about personality. The title is The Personality of the Foreign State. And at MS 7771, Dr. Marston refers specifically to constituting its domestic personality. And the reference at MS 7760 to having capacity for a foreign state to act at the plane, on the plane of English law, it's not about contractual capacity, it's about personality. One can see that from earlier on in the same article, the previous page at MS 7759. One can see the heading, the sentence refers to issues about whether it's the state is a legal person. And Dr. Marston says that without recognition, it's invisible in the English courts, and its acts could not be given legal effect. The corollary would create something, namely a capacity in the foreign state to act as if it were an English person, but it's using capacity in the sense of power to sue and to be sued in that very narrow sense. This is all about personality. In fact, what one can really summarize the trustee's case as being is an application of Dicey's Rule 175, but treating the place of incorporation of the sovereign state as being determined to be England rather than Ukraine. So those articles don't really take us any further because they're dealing with constituted in a very narrow sense as dealing with personality. We can't derive anything about capacities from those, from that material. Then a few comments, if I may, on the Vienna Convention. That's it. I'm not going to turn it up. Authorities, Bundle 19, tab 191, MS 7634. As we saw yesterday, Article 6 is the basic provision providing states have capacity to enter into treaties. But that provision is not unlimited, as we saw yesterday. Article 27 says a state may not invoke internal law to justify non-compliance, but that is stated expressly to be without prejudice to Article 46. And Article 46 in Section 2 of the treaty is headed the invalidity of treaties and specifically refers to competence. A state is permitted to invoke its internal law to negative consent and make a purported treaty invalid if in breach of an internal law obligation which was manifest and a rule of fundamental importance. In that situation, the treaty is invalid and has no effect in international law. So all this shows that the capacity of states to enter into treaties is subject to limits by reference to internal municipal law. That is a possibility. So the idea that a state may choose by signing the Vienna Convention to limit its capacity is not an unusual one, nor is it wrong in principle that its capacity to act is limited by important principles of internal municipal law. Then, if I may deal with the Lotus case that Mr. Howard mentioned, the Court of Appeal rejected the submission based on Lotus itself. That's paragraph 72 to 73 of the Court of Appeal judgment below. And in our submission, without turning it up, the ratio of Lotus is very simple. In international law, it is not necessary to prove a permissive rule allowing a state to act so long as there is no prohibition in public international law on the state's conduct. And the ICJ in Lotus found that there was no prohibition on Turkey prosecuting a person in Turkey for conduct in relation to a Turkish ship on the high seas. And the key passage, just for your lordship's note, is at MS 2900 in the Lotus decision. Restrictions upon the independence of states cannot therefore be presumed the court says. Now, the first and foremost restriction imposed by international law upon a state is that failing the existence of a permissive rule to the contrary, it may not exercise its power in any form in the territory of another state. That's the core reasoning in Lotus. It really goes no further than that. And the case ultimately says very little about capacity, let alone capacity in relation to municipal law-governed contracts. Very briefly, the Tin Council case. Lord Oliver made clear that he considered the relationship between personality and an entity's capacities was not that capacities flowed from personality, but the other way round. The Ordering Council only specified that the ITC would have the capacities of a body corporate, and the House of Lords' conclusion was that it must therefore have personality and was more than a trading name for the member states. And I refer in particular, without turning it up, to Lord Oliver's speech at MS 570. So, if I may then turn to authority. Three holdings out which Mr. Howard relied on. First of all is the appointment of the Minister of Finance. But as I will show you in a moment, the instrument of appointment of the Minister of Finance specifically says it's subject to the budget law. We'll come to look at that document in a moment. Secondly, he relied on the course of dealing. Now, this doesn't really have a promising start. If one looks very briefly at the submissions that were made by the trustee to the Court of Appeal, and if you go, please, my lords, to Appendix Part 2, Volume 2, which is MS 9449. Do you have the paragraph 50? These are
Yes.
the submissions of the trustee to the Court of Appeal, and you see at paragraph 50, Ukraine is therefore wrong to say that these previous issuances could only go to the question of whether there was a representation by conduct by Ukraine due to a previous course of dealing. The trustee does not rely on any such implied representation. Its case is based on usual authority, not ostensible authority by course of dealing. And with regard to the, I won't repeat myself, but with regard to the 31 previous issuances, I made the point in opening, and I maintain that one can gain very little, glean very little from the previous issuances without an analysis, a factual analysis of what those 31 previous issuances involved. And all we have are the front sheets exhibited to Mr. Mason-Jebb's witness statement. And we made the point below in response to the way the trustee put the case that one doesn't likely infer authority from a course of dealing. And just to give you a reference without turning it up, it's in our skeleton to the Court of Appeal, paragraphs 44 through to 49, and the reference is MS 9392. So that's the second limb, course of dealing, relied on by Mr. Howard. The third heading, the third factor he relied on was the holding out by the CMU, but in our submission that was not a holding out to do anything beyond the budget law limits. And as I showed the court yesterday, the prospectus shows, at the very least, an arguable case that the relevant limits were exceeded. Now, on authority, what is vital is that where one is talking about ostensible authority, one has to be able to trace that ostensible authority, the representation, back to a source of actual authority, either to do the act or to make the representation. Whether it's directly or one has to trace back, one has to find an ultimate source of actual authority to do the act or to make the representation. One gets that from Freeman, which we've been to. We also get it from a case called ING, which Mr. Howard relies on in the context of ratification. And the reference to ING, to tracing back to the ultimate source of actual authority. It's Authorities Bundle 1, Tab 5. MS 383 in the judgment of Mr. Justice Toulson, as he then was. And in our submission, that is impossible on the facts of this case and the evidence in this case, at least at summary judgment stage. If we go, please, to Professor Butler's second report. This was before the court below. Could we go, please, to Appendix Part 2, Volume 2. It's MS 9324. Paragraph 3, Professor Butler says, under Ukrainian law, nobody has power to authorize any purported representative of Ukraine to exceed the limits or to ratify their having done so. Simply impossible as a matter of Ukrainian law. And for summary judgment purposes, we say that is sufficient to deal with this point. And can I remind the court, I took you yesterday to Professor Butler, his first report, paragraph 14.2, where he refers to the possibility of Parliament being able, the Verkhovna Rada, being able to increase the limits. But what Professor Butler says is that was not possible to do retrospectively after the transaction was authorised by Decree 904. Now, I referred a moment ago to the instruction to the Minister of Finance. That is Appendix 2, Volume 3. And it's, yes, Appendix 2, Volume 3, page 9735. And if the court has that, one sees there the Cabinet of Ministers of Ukraine instruction, 16th of January 2013. This is an annual instruction. And just for your Lordship's note, this document formed part of the transaction Bible. So it was before the trustee and the note holder. And you see that the reference, the instruction is pursuant to the first section of Article 16 of the Budget Code of Ukraine, to authorise the Minister of Finance to carry out external state borrowings in 2013 within the limits provided by for the law of Ukraine on the state budget of Ukraine for 2013, etc., and on the terms, but within the limits provided for by the budget law of 2013. So that is the instruction. No representation can be said to go further than that. Reference is made to the Mariubeni decision of Mr. Justice Creswell, and in our submission one can see that the Court of Appeal disagreed with aspects of his decision. If one goes, please, I won't turn it up in the interest of time, can I just give you the references? But the Court of Appeal deals with Mariubeni at paragraphs 131 to 132, and in their judgment, Mr. Justice Creswell was wrong in the relevant respect, and we say the Court of Appeal was right for the reasons that it gave in those paragraphs. Now, if I can deal with this point, paragraph 121 of the Court of Appeal judgment, as my Lord Carnworth put it, well, if the Court of Appeal's reasoning in that case is wrong, then it undermines the rest of their reasoning. In our submission, the Court of Appeal reasoning in paragraph 121 was entirely correct, firmly based in well-respected English authority, the rolled steel case. And perhaps we could just take a moment to look at that. That's Authorities Bundle 16. And Mr. Howard referred to rolled steel, but not in this context. If one goes, please, to tab 149. And the relevant passages in the judgment of Lord Justice Slade.
Page?
6311. What Lord Justice Slade says, just below letter F, he says, persons dealing with a company registered under the Companies Act must be taken not only to have read both the memorandum and articles of a company, but to have understood them according to their proper meaning. And he says that the parties must be taken to have known that under the articles of the plaintiff, quorum of 2 was required for the transaction of the business of its directors, and the provisions of those articles related to the declaration of a personal interest. So one must be taken to know, and one must be taken to know by reference to the proper meaning of an instrument. So one does have regard to the objective meaning of an instrument, in this case the memorandum and articles of association. And the notion that this doesn't apply to a foreign law must be wrong, and it can't be right where one is dealing in a transaction with a foreign corporation or a foreign state to rely on ignorance of a provision of foreign law. As the Court of Appeal said, if you need access to foreign lawyers, you get it.
Well, is that right? I see we don't simply refer to Palmer's Companies Law, and it may well be true as a proposition of English company law.
Yes, I say it's a proposition which of general application, and for that I rely on the Donegal case, which the Court of Appeal mentions in paragraph 130 of its judgment. Mr. Justice Andrew Smith said that the relevant party must be taken to have known of the constitutional provisions of the state in question.
Yes.
And Mr. Justice Andrew Smith adds, and could properly be taken to be aware of its effect. So it's in line with the rolled steel approach.
Yeah, and that's all we have. Is, I mean, with great respect to Mr. Justice Andrew Smith, doesn't quite have the status of the rolled steel decision.
No, but where one is dealing with a foreign corporation or a foreign state, one wouldn't expect a different approach to apply, particularly where one is talking about a public law of the foreign state.
I mean, that's the only authority there is.
So far as I've been able to find. But in our submission, the Court of Appeal was right to draw that analogy, and it wouldn't be out of kilter with the rolled steel approach. In our submission, when one looks at, for example, the instruction to the Minister of Finance, there's nothing obscure about Article 16 of the Budget Code. It's specifically mentioned in the instruction, which is part of the Transaction Bible.
Yes,
and it
but
must
I mean,
be
it's
taken
one thing. I mean, one would normally assume the lawyers advising the foreign government and everyone else involved would be properly advised.
Yes.
And one wouldn't expect to be sort of digging around in various bits and pieces.
No, and you don't need to in this case, because the relevant instruction to the Minister of Finance specifically mentions the article in the Ukrainian legislation that we rely on, and the Court of Appeal relied on, in its judgment.
Then why did no one notice that before?
That's a question of evidence which no doubt can be explored at trial. But it's not suitable for summary determination to draw conclusions from what people did or didn't know over the course of a passage of years. But in terms of notice and an arguable case, in our submission, we have done sufficient. And also, my Lord, it shouldn't be lost sight of that the expert opinion did spot the point that Professor Butler mentions, which I took you to yesterday. The breach of the external borrowing limit. And one of the points which comes out in the evidence, and I showed you the passages from Minister Daniluk's evidence yesterday, the extraordinary rush in which the transaction was pushed through, which may not provide an excuse, but certainly provides an explanation for some of the mistakes which were undoubtedly made in rushing through this transaction. But again, that's a matter for ultimately for evidence and not for summary determination. My Lords, on the question of unusual and onerous terms, for the Court of Appeal, we pulled together a series of references from the evidence, from Ukraine's witness evidence, and just for your Lordship's note, without turning it up, references to Ms. Zubchenko's evidence, Ms. Pakachuk's evidence, and Mr. Pashishnik's evidence, but the reference is Appendix Part 2, Volume 2, MS 9513. So, Lords, then, if I may, turn to ratification and to allow Mr. Jaffe some time for countermeasures, I'll try and refer as much as possible to our written case. My Lord, so far as the decisions of the courts below are concerned on ratification, first of all, can I just say we've addressed this at some length, which is why I hope I can take this at some speed to allow Mr. Jaffe time before we conclude. But This is addressed in Ukraine's written case, paragraphs 98 to 132. It's at the end of our written case on duress, paragraphs 98 to 132. Now, so far as the decisions of the courts below are concerned, Mr. Justice Blair held that determining the issue of ratification would require a mini-trial in the light of the number of acts and statements relied on by the trustee as constituting ratification. And the question of whether Ukraine was able to consider and implicitly make and manifest a free choice to ratify in the light of Russia's conduct was a further reason that summary judgment was inappropriate. That's judgments paragraph 172 to 173 of Mr. Justice Blair's judgment. And the Court of Appeal, in effect, endorsed those conclusions, and at paragraphs 147 to 149 referred in particular to the requirement of knowledge for ratification, which was first of all a controversial as a matter of law as to exactly what knowledge would suffice, and secondly the fact as to what Ukraine knew or ought to have known. Secondly, the Court of Appeal emphasised that no one other than Parliament had authority to ratify, and we would add that looking at Professor Butler's evidence, this is a fundamental roadblock to this argument on the part of the trustee. No one, including Parliament, had the authority to ratify retrospectively once the transaction had been entered into. No one had actual authority as a matter of Ukrainian law, which is what matters. And also the fact that ratification was arguably subject to duress, or which we submit as not necessarily the same thing, which was not necessarily an exercise of free will. So not necessarily exactly the same thing as the law of duress, but the question which the law of ratification asks is whether the ratifying party did its act as a matter of free will. So the same facts which may be said to amount to duress, even if you were against me on all the arguments on duress that we debated over the first 2 days, the question of whether there was free will on Ukraine's part is a separate question, which would require a very deep factual analysis of what Ukraine did and under what pressure and in what circumstances. And in our submission, there is no good reason for the Supreme Court to come to a different conclusion to the courts below. Now, our written case, paragraph 100, we set out the 4 requirements of ratification, the first being the absence of authority to ratify. And we make the point that the Court of Appeal made this point at paragraph 148 of its judgment. And the first point under this heading is there must be authority to ratify, not just to do the act. And that's the point which Bousted makes in the supplement. The relevant authority has to be in relation to ratification. And as I said a moment ago, the fundamental roadblock, at least for the purposes of the summary judgment application, is Professor Butler's evidence that there was no such actual authority to ratify. And that is ultimately why we say the trustee is unable to identify anyone with the necessary authority to ratify.
I was thinking aloud, Mr. Thank you.
Yes.
The first issue we've been looking at in this case is capacity to enter into the contract, and the question whether Ukraine as a state had capacity to enter into the contract. And if we're with you on that, then that's an end of the case. So it's only if we're not with you on that, and we conclude that Ukraine did have capacity to enter into the contract, that the question of authority arises. Now, authority has to do with whether something done by an agent binds the principal. The principal here is Ukraine, the state. Well, we've already decided on this hypothesis that Ukraine had the capacity to enter into the contract. So I'm wondering really what the Freeman and Lockyer's problem is. I take your point that that Freeman and Lockyer's and Rolled Steel, in the context of companies, require the person who enters into the contract and who lacks actual authority to do so to be able to trace his authority back to somebody, normally the board of directors, who would have authority.
Yes.
Here, the attempt is to trace back through the constitutional arrangements of Ukraine the authority of the minister to the state on whose behalf he sought to enter into he purported to enter into the contract.
This is one of the difficulties with this case, where one is applying rules applicable to a foreign state, because in the passage I showed the court yesterday, as Professor Butler makes clear, Ukraine doesn't draw a distinction between capacity and authority, but what it doesn't take away is the requirement of the court applying the Freeman and Lockyer principles to find an ultimate source of authority. Now, if capacity and authority in Ukraine are not distinguished, one is still faced with the same problem.
Well, I think the problem you're highlighting under reference to the company law cases is effectively that ultimately there has to be a principle with the vires to do what the agent purported to do. Otherwise, tracing back via ostensible authority isn't going to cure the problem.
Raises a problem which is difficult to resolve on a summary judgment application, but how does one deal with that where vires and authority are, as a matter of the foreign law, the same thing, effectively? And in Professor Butler's opinion, everything, ultimately, if there's no power, the act is a nullity.
Well, we've seen that under the constitutional legislation, the conduct of economic affairs is the responsibility of the cabinet, under the control and subject to accountability to the parliament. And the cabinet, in turn, has the power to entrust the conduct of these matters to the minister. And you're focusing on the inability of the lack of capacity of the cabinet to behave in a manner which contravenes Ukraine's internal law.
But it's also a question of authority too, because actual authority, for the purposes at least of this application, is also, its common ground has to be governed by Ukrainian law. And if one is trying to trace back, there is no authority, whether on the part of the Cabinet of Ministers or on the part of the Minister, to authorise someone to make representations to act in excess of Article 16 of the Budget Law. Whether you categorise it as capacity or authority, it doesn't really matter for present purposes.
Thank you. I won't take up more of your time.
No, not at all, it's helpful. But it highlights a difficulty where one is dealing with a state who has legal principles which are not directly analogous to English law principles, which does draw a distinction between capacity and authority. The second point we make in our written case is that there is no unequivocal act of ratification. I'm not going to go through all of the acts. We deal with this at some length in our written case, and the reference for your lordships is the paragraphs 111 through to 115. But if I'm right on my first point, they don't arise. The third point we make is that there is no requisite knowledge for ratification, and This is a difficult area as a matter of English law as to what knowledge is sufficient to amount to ratification, and it was really one of the reasons which the Court of Appeal focused on in particular. And perhaps we could just look very briefly at the SEB Trigg case, which is at Authorities, Volume 3, tab 18. And if one goes, please,
Page.
MS 1241.
Could I just mention something, Mr. Thank you, we've got this useful index of authorities.
Yes.
But it's not terribly well adapted for people who, like me, who are trying to work out on the MS. I don't know whether it'd be possible for someone, all these people, to produce a version of this which had the MS numbers.
Very easy to do that, and we'll do that
Be
in the
very
next day
helpful.
or so, if that's acceptable
Thank
to
you very
Lordship.
much. Sorry.
Um,
And so what page were we on?
so 1241, my lord.
If I have the page, I can just press this and it pops
Yes.
up. Magic.
And this is really it's a judgment of Mrs. Justice Gloucester, as she then was, and it's one of the most comprehensive analyses of the law relating to ratification which we have. And if one goes, please, to paragraph 97, subparagraph 7. Can I just ask you, actually, while we're on 1241, you see a reference at Little Roman 4 in the right-hand column to ratification being a unilateral act of will. That's where I get act of will from, which is not necessarily in our submission the same thing as duress. So Mr. Howard is wrong to say that if we lose on duress, we necessarily lose on ratification. It's not necessarily the same thing. And then if we go, please, to 97.7, 1242, and you will find that in the right-hand column, about 5 lines down. What her ladyship said there was that what might otherwise be regarded as an act of ratification may be vitiated by want of knowledge if the ratifier did not have full knowledge of all the material circumstances in which the act was done. And then her ladyship quotes from the judgment of Mr. Justice Waller, as he then was, in the Suncorp and Milano case. And one sees his lordship said there in the quote, he should have full knowledge of all the material circumstances in which the act was done, unless he intended to ratify and take the risk, whatever the circumstances may have been. And that, in our submission, requires a factual inquiry, which is not suitable for summary determination. The precise test depends on the context, as the judge makes clear. If we still have the judgment open at paragraph 133, paragraph 133, which is MS 1249, and her ladyship says in the middle of the right-hand column, in my judgment, whether someone has full knowledge of all the material circumstances, to use Mr. Justice Waller's words, for the purpose of ratification, is essentially a fact-specific inquiry, which is necessarily dependent upon the particular circumstances of any case. Sometimes it may be appropriate to have regard only to the person's actual knowledge. Sometimes it may be appropriate to consider what could or should have been known to him. So one sees a very fact-sensitive inquiry. And the Court of Appeal was correct to say at paragraph 147 that the test of knowledge involved disputed or controversial questions of law as the scope of the test. And Mr. Howard's submissions really don't take away the need for a factual inquiry. The trustee accepts that it can't determine actual knowledge on the part of Ukraine summarily, but in our submission, looking at the fact-specific nature of the inquiry, the same goes for constructive knowledge too. And then finally, a question of no free choice to ratify, the fourth requirement. We deal with this in our written case at paragraphs 128 to 132. The trustee describes our case as fanciful, but you only have to describe something in that way to show that it plainly requires a trial. The trustee is disputing causation, effectively, which is quintessentially something which is not suitable for summary determination. The trustee accepts causation of pre-contractual duress, for example, is unsuitable for summary determination. And really, there is no valid distinction for this period, particularly when one is talking of events after the invasion of Crimea and after the Russian interference in eastern Ukraine in terms of vitiation of consent or lack of free choice to ratify. So we say that even if pre-contractual duress is held to be non-justiciable, this...
Give me one moment. Yes, thank you very much.
My Lord, just to address my Lord Culmworth's question about hyperlinking, I'm told that the index at MS3 onwards is hyperlinked. But if your Lordship has any difficulties with that, we will...
Yes, the index there is, you're quite right.
You want the numbers actually? Yes.
I mean, I can get it done internally.
No, we can...
It's just that I find it quite useful to use. I mean, I'm a sort of hybrid in the sense I use paper and machine.
A hybrid.
Sorry.
My Lord Reed's question, the questions of capacity and authority are separately considered in Freeman and Lockyer at page 506 of Lord Justice Diplock's judgment at MS 3665. So one needs to consider them separately.
Thank you.
My Lords, unless I can assist you further, that's all I wish to say on ratification.
Thank you very much. Jeffy.
My Lords, 4 very brief points on countermeasures in reply. First of all, the difference between countermeasures and duress is, of course, that there is already an English law defence of duress. There has not previously been recognised an English law defence of countermeasures. That's, of course, why Ukraine has to roll the stone up the hill of incorporation in relation to countermeasures, but not in relation to duress. The second point is that there's clearly an arguable case of a breach of customary international law justifying countermeasures. It's the clear view of the United Kingdom, and it's the view of the General Assembly. Now, I only need to show at this stage that there is an arguable case.
Yes.
And I don't think that Mr. Howard actually sought to dispute that. He's, of course, quite right that the General Assembly cannot bind any state, including the United Kingdom, as a matter of international law. That Russia has committed a grave breach of international law, a breach of Jus Cogens, by its invasion and annexation, for example, of Crimea. The third point is whether or not the doctrine of countermeasures is indeed a principle of customary international law. Well, the answer is yes. I showed the court the International Law Commission's work as a shortcut rather than going to the authorities. I'd entirely understand it if the court don't believe what I'm about to say, but some small effort was made to reduce the number of authorities. But if you want one place to go, I'd recommend the Gabsikova and Nagimaros decision. I think it weighs in at a good couple of hundred pages from the International Court of Justice, and the other arbitration decisions, which are also cited in relation to Article 22. And the basic position is that for a state in a position of Ukraine, which is of course far smaller and less militarily powerful than Russia, a countermeasure may be the only step which it can realistically take to defend its interests. Now, what Mr. Howard says in response to that is, well, it's not a countermeasure because it's only taken against a municipal law right, not an international law right. But states have always taken such measures, even if the obligation which is being breached is municipal, not international. So an economic sanction prohibiting compliance with a municipal law contract is perhaps the classic example of a countermeasure. And of course, such a sanction may affect third parties as well, including innocent third parties. The classic situation of a sanction is an entirely innocent individual or company may be prevented from compliance with a contract as a result. So just to take the most straightforward example, if one state annexes some of the territory of its neighbour, the neighbour might, as a legitimate countermeasure, stop shipments of arms under a municipal law contract in order for the state to protect its absolute and essential interests as an alternative to the resort to arms. To say that in customary international law, a state would be able to resort to armed conflict in self-defence but not be permitted to breach a contract, in my submission, can't be right. Now, we're not aware of any authorities, for example, from the International Court of Justice, which say that. One of the reasons, of course, is that in recent decades, the more restrictive theory of state immunity has developed, and states will often enter into a municipal law contract as opposed to entering into a treaty. Those contracts will, of course, ordinarily be enforced by municipal courts. That's why those issues begin to arise. So we say that a countermeasure which is taken against a municipal obligation is at least arguably a countermeasure which may be permitted by customary international law. Then the final point is on incorporation. The presumption is of incorporation. That doesn't necessarily, in our submission, require a countermeasure to adapt or apply some existing principle of English law. A suspension of a right is a pretty well understood concept. Within it can readily be introduced as a common law principle in exactly the same way as an immunity, for example, from criminal proceedings. There is no requirement for an exact analogy, and Mr. Howard did propose in his earlier reply submissions on duress that contractual obligations could be suspended or abrogated in his Q8 example, without having to persuade the court or explain the exact link with an existing cause of action or a defence. And in this case, the only remedy which is sought is in effect a stay of enforcement, which is a particularly familiar concept. Ultimately, there is no difficulty, either constitutionally, practically, or cutting across legislation, that would prevent the recognition of an important customer. Assist the court further on countermeasures.
Thank you very much indeed, Mr. Jaffe.
Order.
Yes.
Agreed that I would have just 15 minutes, which I
Yes, of course.
Just before I address ratification, there are just two things that were referred to which hadn't been referred to before. One is the rolled steel point.
Yeah.
As your lordships know, the position that is set out in rolled steel has now been abolished for English companies. So the doctrine of constructive notice is overridden by Section 40 of the Companies Act 2006, and that's referred to in Balstead 8037, which is in the Supplementary Authorities, tab 9 at MS 550. The second point is you were referred to the Donegal case, the decision of Mr. Justice Andrew Smith. Doesn't say what Mr. Thankey was saying. In that case, the counterparty had been sent a letter specifically referring him to a specific provision of the Constitution. It was in that context that
But
Mr.
he says he knew and can be taken to have understood its effect, but it's very much a sort of throwaway point
Exactly.
in a very, very long judgment.
Yeah.
I was just looking at it.
Your
So we
Lordship.
don't really have any authority on the application of the rolled steel principle in this sort of context.
Well, and certainly in relation to the question that's being put forward is that somebody is supposed to know foreign law.
Yes.
And it's not simply foreign law, it's that, I mean, if one read what is here, and if you read, I showed you the relevant provisions, one couldn't see that there is this limit. You require some...
I mean, the trouble is, I suspect if one looked back at the rolled steel authorities, I mean, it's quite a familiar principle, one would find as being a sort of English law principle of public policy.
Yes.
Based on the concept of a company under English law.
Yes.
But I'm just, I
that
haven't
is-
looked at that for a long time.
No, I think that is right, but it's then when you're applying it to our situation, in my submission, it's A, not analogous, and B, where English law has moved on in relation to the point I made to you, that one is not treated as knowing all aspects of English law, let alone foreign law.
The point I raised with Mr. Thankey, and on which he referred me to Freeman and Lockyer, maybe worth, at any rate, looking at it in a bit more detail. The whole issue of principal and agent has to do with one person acting on behalf of another, and the question is whether he had authority to do what he purported to do.
Yes.
And and as Lord Justice Diplock says, in a case, I mean, Freeman and Lockyer is another company case.
Yeah.
And so you're looking for the person to have been authorized or held out as having authority to act on behalf of a company, for example, by entering into a contract, which is traceable back to somebody who was actually responsible for the running of a company's business. For example, the board of directors. But the problem which you're liable to run up against, at least prior to Section 9 of the 1972 Act, was a viris problem if the company's memorandum and articles didn't permit what had been done.
There are
And
two
what I'm wondering in the present case is we have the conduct of economic affairs of Ukraine being entrusted to the cabinet.
Yes.
And you're tracing the you're seeking to establish that the minister, at any rate, had the ostensible authority given to him by the cabinet, there's an argument against you that that Ukrainian legislation rendered what was done ultra vires the minister, and for that matter, ultra vires the cabinet. But if the principle here is the state, and the state has unlimited capacity itself, then there's no equivalent to the memorandum and articles limiting the, so far as English law is concerned, limiting the capacity of the...
that was the submission I made to you. That
Well, I'm afraid it's taken me a long time to grasp it.
I wasn't meaning to claim pride of authorship, but maybe I didn't make it sufficiently clearly. That the point is that if we're right on capacity, then one's decided as a matter of English law, Ukraine has unlimited capacity.
Yeah.
So when you apply Freeman and Lockyer, there is no capacity issue which would apply to a company. What I accept is that what you have still got to show is that the person who, for this purpose, the CMU has apparent authority, that they actually have that from the state, that it isn't just pulling themselves up by their bootstraps and saying, I have authority. But the simple reason why they do is they are appointed as the CMU. My Lord, turning to the ratification points, and I can deal with those very quickly, the suggestion is that knowledge is controversial. The answer to that is it is not, and for the reasons I've explained, is that the first thing is you only need to have authority to do acts which constitute ratification. The second is you only have to have knowledge of the transaction itself. So that what Ukraine is saying is that the relevant material circumstances were that the acts of the minister were contrary to Ukrainian law, and they say no one appreciated that fact. But all of that is irrelevant. And Mr. Justice Hamblin, in the case I showed you, has shown that that isn't part of the relevant test. Now, if I am right on the test, there is no English difficulty about ratification. As to the point that's made about duress and the now broader way of putting it, which is not limited to an English law case of duress, essentially it said, well, I didn't intend to do the acts, or I did the acts because my will was overborne. But as a matter of fact, it is fanciful in a situation where what Ukraine says is I didn't know that I had an entitlement to avoid the contracts, and I was just paying on the notes because I regarded them as valid. In that situation, it's difficult to see how anything has overborne your will. You just paid on what was, as far as you were concerned, an existing contract, and as a matter of English law, by your paying and recognising them, we submit that is the plain case of ratification. And you referred to the Seb Trigg case, the Mrs. Justice Gloucester's case. In our submission, there's the part that you were shown at 97 sub 7, that there's no development or analysis there, and Mr. Justice Hamblin's views, as explained in Balstead, represent the current state of English law. And in our submission, where the law, where these issues are, where the English law is clear, there is no need for a trial to explore issues which are irrelevant. Indeed, the same point arises in relation to, say, capacity. We are dealing with a straightforward, whether you regard it as straightforward or not, but a point of English law as to whether it is relevant at all to look at Ukrainian law. If we're right, you don't need to have a trial with disputes about Ukrainian evidence, which is just completely irrelevant. So, my Lord, I see we've managed to finish 10 minutes early. That's all I wanted to say, unless I can assist you any further.
Thank you very much, Mr. Howard. Well, we're very grateful to all counsel for managing to keep so well to their time estimates and complete this hearing within the time allocated to it. And we're, needless to say, very grateful for the quality of the submissions we've received on a very wide range of issues. We'll now take time to consider our decision.